Good morning, everyone. Thank you for joining Orleans PC and eTitle Agency for today's webinar. My name is Connie Kinzer, and it is my pleasure to introduce our esteemed speaker for today's presentation, Jacqueline Vella. Jackie is a title attorney for Orleans PC. She is experienced in residential and commercial real estate transactions. Jackie is also notary public and is fluent in both English and Spanish. Ms. Vella is passionate about serving others in her community. She is an active member of the Real Property section of the Florida Bar and the Collier County Bar Association. I will now turn it over to Jackie.
Thank you, Connie, for the introduction. And good morning, everyone. And thank you for joining us for today's discussion on real estate, as we go over the key tips in avoiding the most common transactional delays. In today's discussion, we'll start at the basics and together go from the foundation of a residential transaction, getting your contract, all the way through till we get that clear to close, and making sure your client secures that marketable title. Now, this presentation is 30 minutes long and packed with information that may or may not be familiar to you. So if at any point you have any questions, or maybe you simply need clarification on something, go ahead and submit your questions along with your email and contact information, and we may address them individually at a later time. As we go through the easier topics and start going over some of the more complex items, please remember that this presentation is not meant to be jurisdictionally specific, meaning the information provided to you today, it's general and not related to your particular state. That said, eTitle and Orleans, being agencies in multiple jurisdictions, we have gathered the 6 most common questions we are asked to share with you, including what you'll want to keep in mind in order to make sure you avoid them. These will be our key tips. And with that, let's begin. Starting with contract formation and its preparations, we begin with reviewing our groundwork, starting at what form we use, to its terms, and finally, certain contract formalities. We will be providing you with some questions, hypotheticals, and examples for you to remember in hopes they will help you recognize a red flag or its possibility so you can confidently prevent it from happening with hopes of avoiding it altogether in the future. Your flag scanner starts here at the use of form, aka your contract. Although there are many types of forms or contracts that can be used for residential transactions, each jurisdiction may have their preferred form. For example, in Florida, the most common form used is FAR/BAR, which is a contract that was jointly authored by the Florida Association of Realtors and Florida Bar. Alternatively, some counties may have its own designated form, specifically tailored to it. For example, in Florida, Collier County's preferred agreement is authored by the Naples Area Board of Realtors, or NABOR for short. And of course, we have our own independently prepared contracts, which can be used from time to time, but these agreements seem to be more used in commercial transactions. It's important to know what form you should be using at all times. That said, some of you may be asking, what's with this jurisdictional distinction? Right? Beyond the state form rules and formalities and procedures, are counties really that big of a deal? Is it possible to use, let's say, a FAR/BAR contract in Collier? That answer is, it depends. And I agree, it depends is not the best answer. So what does it depend on? Your client's goal, right? By matching your client's goal to the terms of the contract, you'll be able to identify which contract is more favorable to the transaction. Terms, contract terms and provisions, know them. What is your client's goal? Have you had the discussion? Does the contract have the provisions that encompass said goals? Go over your contract with your client in every stage, initial offer, counter offer, and prior to acceptance, and highlight any terms and provisions that could negatively impact your transaction, such as dates, conditions, restrictions, disclosures, and any other provision or term that you and or your client find important enough to double back on. right? So let's say you have a contract that is based on a standard term of the agreement and nothing more, meaning unless otherwise provided for, you've agreed to the defaulted language and dates therein. Ask yourself if that truly matches with your client's goals, the intent of the parties, and their availability. Many times this notion is brushed over, and it's not until later that the parties get into a disagreement and the transaction gets put into a halt because of it. So going back, how can we avoid this? By simply having the discussion and knowing and understanding the terms of your contract from the very beginning prior to its inception. Here are some questions and hypotheticals that can help. Let's say you have a contract in hand contingent on the defaulted standard terms. Ask yourself, are the terms within your contract on its face complete? Are these terms clear to you and your client? What about a non-standard term, right? So ask yourself whether or not you need them. Non-standard terms are used here to identify terms or conditions that differ from what's already defaulted. For example, maybe your client has agreed to a longer deadline or a shorter contingency period from what's already customarily used. Here, it's important to ask yourself if these terms are reasonably attainable and mirrors your client's intention. And of course, in certain circumstances, you may need a special addendum or rider to attach to your contract when you need to address something specific. You could even need more than one of these. Before adding any of these documents, you should make sure that the documents are complementary to your contract and that the language within these documents are clear and concise, inclusive of your client's ultimate goal. So the last items on this flag scanner checklist pertaining to this section call for you to ask yourself if you've completed all the blanks in your agreement, whether you've reviewed and made sense of all the deadlines, and finally asking yourself whether your signed agreement was executed properly. So in checking your blanks, you really are looking for any incompleted items in your agreement. It's good practice to make sure that all the blanks in your contract are completed or designated as non-applicable when appropriate. The reasoning behind this is to deter any possible miscommunication between the intent of the parties as well as any errors. For example, the two most common items left blank or incomplete, leaving room for error, correspond to contact information for parties and dates, when your clients intended a different date from that of what's defaulted. Speaking of dates, what about deadlines? Whether you are currently in the middle of proposing an offer or a counteroffer or in the stage of acceptance or even in the final agreement itself, it's important to make sure you have thoroughly reviewed your deadlines. As you're combing through your agreement, you need to ask yourself, what's the deadline? Unless you communicated otherwise and there is some sort of understanding, you can miss a window of opportunity by not knowing your deadline. Or on the negative side of things, your client can default. And finally, after you've checked your blanks, confirmed your deadlines, and made sense of the agreement in its entirety, your parties go to sign. Ask yourself, are any of them foreign to your state? Depending on your jurisdiction, there may be a specific formality in how a contract is to be executed. For example, although in Florida and Michigan do not have a requirement for signatures on a contract to be notarized or witnessed, some foreign jurisdictions may require notarization or an apostle certificate in order to even validate the contract. Knowing your party's jurisdiction requirements are key to ensuring your contract is valid. So, by using our flag finder to seek out the potential red flags at the onset of our contract or a transaction, we should be feeling more confident that the likelihood a transactional delay will arise from this stage is now substantially diminished, and any future transactional delays may arise solely due to title-related matters. As we now begin to turn our gears, becoming more vigilant of the possibilities and common setbacks that occur when clearing title comes to play, Together, we will pinpoint certain areas where potential red flags are common. This way, should you find yourself in a similar context, it won't feel so foreign to you, making it much easier to either prevent or find a resolution at a much quicker pace. So starting at the nuts and bolts of it, we ask ourselves, what is title insurance? And the short answer is, title insurance can be considered both a shield and a sword. So what's the benefit of having title insurance? In a word, protection. Depending on your jurisdiction, an owner's policy is either voluntary or required. Generally, an owner's policy is purchased at closing for a one-time fee and is issued to a home buyer in the total amount of a purchase price. An owner's policy will protect a purchaser against certain challenges or claims against ownership or hidden defects in title connected to the property, which, for example, may arise due to some sort of predated matters in the future. This type of policy remains effective as long as the owner holds an interest in the property. By the same token, a loan policy will protect a lender's interest in property based on the total amount the purchaser is borrowing from the bank. In general, it will remain effective until the loan is paid off. Right, so regardless if you're in a jurisdiction which mandates you or your client to take out an owner's or lender's policy, understanding title insurance, the distinctions and benefits of the types of policy will allow you not only to educate your clients, but also validate their objectives, right? So there's no surprises in the future. So here's the big question. What's involved in having a policy issue? What role does an agent or individual take? Well, being a creature of habit, any policy will be subject to the terms and conditions of the agreement, and the agreement itself will take the form of a title commitment. And the title commitment will inform you and your client of any possible defects in title, encumbrances such as liens and judgments against the property, or some other issue found in the chain of title, aka your potential red flags. Now, bear with me. I know this is a lot of information in a short time. So before we dive right into our title commitment discussion, let's paint a picture. And as we do this, remember what your role is. You want to make sure that the title commitment requirements are met so we can dodge those red flags. Painting the picture, we will now imagine that you have your title commitment and you're sitting down with your client to go over the report. And your goal is to discuss the commitment's requirements and exceptions, what documents your clients may need to provide, what documents the other parties need, the list goes on. But your mind goes blank. You see a whole lot of writing and you're not entirely sure how to explain it without confusing yourself or your client. Believe it or not, this scenario is no stranger to the industry. I mean, making sure that you and your client not only understand the documents and other requirements needed, but also the continuous follow-up and support in order to make sure that your transaction can close on time is more common than you would think. But the good news for you is for those days that your mind goes blank, here is your breakdown. A title commitment is divided into 3 parts, your Part A, B1, and B2. Schedule A provides you with the general information of your transaction. For example, identifies the proposed insured, identifies the property information and legal description, the effective date of the commitment, the types or type of policies and amounts issued, and so forth. When reviewing this information with your client, have them double back and to the best of their ability confirm that this information is correct. This way, you have dotted your I's and crossed your T's in confirming that the current title holder matches the name on your seller's contract, thereby eliminating any future surprises pertaining to ownership. This is your first stance. Schedule B1 are the requirements we spoke about, the ones you want to make sure your client meets. This schedule will list a variety of requirements that may or may not require your client to actually do the legwork, as the title agency or other agent will take care of it. For example, obtaining a payoff for a mortgage. More often than not, your agent will probably take care of this for you. When reviewing this section with your client, make sure that there's no questions left unanswered. If you're unsure of the answer, make sure to ask. The last schedule is your B2, which encompasses your exceptions to the policy. In simpler terms, these are the exceptions that will not be covered by the title insurance policy. Make sure your client understands them. If your client is not comfortable with an exception, it never hurts to reach out to the agency to see if the exception can be removed. For example, if there's an exception regarding certain encroachments on the land, it may be possible to remove this exception with a land survey. Lastly, the timing. It's good practice to double check your contract for any title-related deadlines, right? So what if there's a judgment or lien that needs to be cleared prior to or at closing? Will it? What if a lender's involved and the lender needs other requirements in addition to those on the commitment for obtaining, let's say a loan approval? By observing these deadlines, you may not only reduce the cost and prevent any possible delays to your transaction, but provide the necessary support to your client. This brings us to our questions and answers section, where we will be going over the 6 most common questions we are asked and their answers. The first few fall under the umbrella of conveyances, and the others dive into other common issues that arise, causing delays to a transaction. The first question pertains to divorce, and the question goes, I am selling the home that I got from my divorce settlement. However, the title agency tells me that my ex is still on the title as an owner, even though I provided the marital settlement showing that I was awarded the property. What should I do? Is this a problem? Well, the answer is, as a practical matter, it will depend on the availability of your ex-spouse and, of course, the state laws. For example, if your ex-spouse is around and willing to prepare and execute let's say, a quitclaim deed conveying his or her interest to you, then, keeping in mind your contract deadlines, of course, simply make sure that you can get the instrument prepared and executed in time for your closing. That said, if you find yourself in a situation where you cannot find your ex-spouse or he or she is simply not available, well, your question will now become a little more complex and one to discuss with your attorney. Our second question regards probate and follows, my client is the only surviving child to her parents, now deceased. While living, her parents owned a home together. Some time has passed and now my client wants to put the house up for sale. My client assured me that she is a homeowner since she inherited the property when her parents passed away. Now that we've executed a contract for sale, we are told that my client isn't the owner. What should we do? Will we be able to close? Well, the answer to this one will strongly depend on your jurisdiction. If you're in a jurisdiction that requires the administration of probate to properly devise the property interest, then it's likely that your transaction will be put at a standstill until the administration is conducted. However, there are some jurisdictions in which the full administration of probate isn't required, and a title company or other counsel can prepare an affidavit and other legal documents that can evidence your ownership interest. So, in the most simplest ways, it just depends. If you're in the middle of an ongoing transaction, it's possible that you can resolve this while it's still going on. It's also possible that the parties can agree to an extension. That said, the best practice is to simply avoid this by doing your due diligence ahead of time. Know your sellers. Sometimes it's possible to even create a contract for sale with some sort of contingency upon administration being solved. You must take your time. Question 3 concerns power of attorney, right? And it follows, my client is not able to sign her closing documents, but says her sibling is her power of attorney. Does my client have to attend if her power of attorney can make it? And this answer also depends on your jurisdiction and the governing laws of power of attorney, right? The most important thing to note is whether or not your power of attorney affords you the powers to conduct the type of transaction you're doing. So for example, does the power of attorney allow you to sign for security agreements, transfer interest in property, encumber property? Depending on your jurisdiction and what your power of attorney says, it's possible that the title company, agent, and/or lender accepts the power of attorney as is, keeping in mind that there is always a possibility that a new power of attorney will have to be drafted and executed prior to closing in order for your agency powers to even be valid. So, what is the takeaway? Never assume the document will work. As soon as you're aware that your client may be using a third party as an agent, make sure to ask your client for that power of attorney document so you can timely provide it to your title company, lender, and/or other agency for review. Question number 4 deals with business entities. Mainly, it calls to ask if the seller is a business entity and goes, my client is selling her property through an entity, but its articles and/or other governing documents do not have her as the authorized signer. How should we resolve this issue? And this is a great question, as it raises the question of ownership. Your jurisdiction will determine what kind of documents will be required to certify an entity's good standing, and what legal documents are necessary to prove who is the authorized signer or who can convey and transfer and encumber property. If your client has signed a contract but doesn't seem to appear on any of the governing documents, it doesn't instantly mean that you're at a loss, right? You'll just have to ask the appropriate questions. It's possible that there was a change in ownership and out of pure laziness, procrastination, or some other reason, no amendments have been done, naming your client as the signer. If this is the case, you'll have to work with your client to make sure that she obtains the proper documents and timely provides them to the agency issuing title so that there's no unwarranted delays. That said, of course, in the parade of horrors, fraud is possible. So before any of these scenarios come about, the best practice is just to do your own due diligence beforehand. Go online, search your state's corporate division, and ask your clients for the governing documents in advance. Question 5 discusses mechanic liens and follows, my client is selling his home but recently had construction done for remodeling purposes. He had recorded a notice of commencement in the public records and it's still showing as active. Does he have to terminate it? Will this cause any delays to our transaction? And this issue commonly arises when priority of who gets paid first comes into question, right? So typically you have a lender involved, and the answer to whether your client will have to terminate his notice of commencement prior to our closing and what kind of delays are possible isn't a question that can be answered generally. This answer will strongly depend on the recording act of your jurisdiction. Why? Well, without digressing into a more complex response, each state has its own recording statute governing the priority of payments, And these statutes play a strong part in determining who will win in that chase of who's going to get paid first. So it's important that you familiarize yourself with your state's Recording Act. And finally, our last question, 6, concerns judgments. Judgments really against sellers, right? So it says, my client's title commitment calls for a satisfaction of a judgment against my client, the seller. But she says that this judgment has nothing to do with her because it's not her. Will this be a problem or cause any delays for our closing? Well, the answer here in short is probably not, right? So I know again with the conditional responses, but in general, sellers are required to pay for their judgments. That said, depending on your title company or agent, as well as their underwriter, they may be able to provide you with an exception to this rule. Assuming that this option is available in your territory, how would it work? Simple. By having your client execute an affidavit, sometimes referred to as the not me affidavit or a non-identification affidavit, swearing under oath that, in lesser words, the person named on the judgment is not your client and has never been your client. So, for example, if you're able to get this affidavit executed and recorded by your client, then the opportunity for any closing delays to happen will now be drastically lessened or avoided completely. And this brings us to the end of our presentation. Thank you for spending this time with us. I went ahead and jotted down my contact information here. If you have any questions that this presentation did not cover, or if you need clarification, or maybe you just want to chat, please feel free to reach out. Thanks again.